We get lots of questions about contracts. So I'm going to go through some contract fundamentals for you. Firstly, what's a contract? Well, you need offer, acceptance and consideration for a contract. What that means is, for example, a price on a shelf is an offer. Acceptance is agreeing to pay that amount. Consideration is the payment of money. Consideration doesn't have to be the payment of money. It could be doing something instead. So we sometimes come across people who say, I entered into this agreement with so-and-so, they agreed to pay me a certain amount of money, I went and did all of this work, and then they changed their mind. Doing all of that work, that can be consideration, which creates a binding contract. So the first thing is to understand what a binding contract is. It doesn't necessarily have to be signed, it can be verbal. So starting place is, has there been offer, acceptance and consideration? And do the parties intend to go into a contract, even if they are not sure whether they're going into it yet? So that's the start. And then we've got who. You need to know who you're going into a contract with. It's really interesting to me that sometimes we have people come to us and they say, I'm going into this agreement, but then they don't actually identify who it's with, because it's not always a person. Sometimes it's a company, sometimes it's a trust. And we need those specific details so that if anything happened in the contract, if something went wrong, it is possible to come back and take action against the right person. Now, the other thing about who you enter into a contract with is, many years ago, we had a client who had a contract with a well-known cricket player post their cricket career, and it was a property development deal. It all went south, and they tried to sue. But what was discovered was that there were a whole lot of similarly named companies, and the company that our client went into an agreement with had no assets. So it just went belly up when they were sued. So it is important to understand who you are going into a contract with and doing a little bit of research on who that is. We've got a client at the moment looking at an international deal. We've said you need to verify. So we've checked that the company is actually registered in the country where they're going into business. And we've suggested they do a little bit of Google searching on the people who are named as directors of that company. You just need to do a little bit of homework, not always a lot. The next thing is, why are you going into a contract? Is this important to your business? Some people get really enthusiastic. They've seen an opportunity, they go, we've got to do this, we've got to do this. Be aware that timing is never as critical as you think. We have clients who come to us just before Christmas and say, oh, no, I really need this to happen, but go into a lease between Christmas and New Year. Why would you do that? Christmas and New Year is one of those periods where if you don't already have a setup, you're not going to make money in that period. And if, for example, you're needing to fit out premises, it's going to cost a lot more money in that period because most of the tradespeople are on holiday. So think about timing as well as why you're going into an agreement and whether it's the right kind of agreement for you. For example, I've had people come to me and say, oh, we want to go into partnership and do X, Y, Z. It's not a partnership. It's a joint venture. A partnership is a very specific legal relationship, and it has specific liabilities that you may not want to take on. So it's looking at the type of agreement that you want to go into as part of your why before determining what the terms and conditions of that contract are going to be. Another aspect, where and when. Timing within contracts can be very important. So for example, in leasing contracts, there's often a period before the lease starts to allow for fit out. Or you may be paying for the fit out period. That's something very important to check, because what if something goes wrong in the fit out? You know how hard it is to get materials and trades these days. What if your fit out extends an extra 6 weeks? Do you want to be paying rent in that period? These are really important things to look at. If you're going into some form of consultancy agreement, is there a way to terminate it when the services are concluded, or you've seen that you've achieved everything you want to achieve with that consultant? This is the timing of agreements. How do you bring them to an end? Is there a natural conclusion to them, or does some action have to be taken to bring them to an end? As consultants or education providers, we work with a bunch of people who, or service providers rather, who in the marketing space, for example, they might have ongoing, automatically renewing contracts. To end those contracts, you have to take a positive action to bring an end to it, regardless of which party wants to end it. These are timing considerations in the contract you're going into. Where you're going into a contract is also important. If you're dealing with people who are international, how are you protecting your interests? Suing people internationally is not easy and it is expensive. So you've got to understand what are the dispute resolution options available to you if you're going into a contract with an international person. How do you protect your interests in terms of handing over assets before payment or making payment before receiving assets? There are escrow services to protect this sort of thing. We're looking at one for a client at the moment where some software may go into escrow for a period of time, and that will be pending payments so that our client does actually get paid. The timing and the place of your contract can be important, so you keep that in mind as well. How are you going to go into the contract? A lot of people come to us and they say, well, I never signed anything. That doesn't mean there wasn't a contract. Conversations. You know, at the beginning I said offer, acceptance, consideration. You can do that verbally. There are only very few contracts that have to be in writing, and they're contracts around land, contracts around the transfer of copyright and the transfer of trademarks. Those sorts of things, very specific circumstances. General business agreements don't necessarily have to be in writing, and certainly they don't necessarily have to be signed. So when you've got people who come to you and say, oh, well, I never signed anything, that doesn't mean they didn't agree. It doesn't mean they're not bound. And the same goes for you. Keep in mind how you're going into an agreement. And what we say to people is, if you're discussing things over the phone, or you've got a handshake agreement happening, it's all verbal, we trust each other. Great, love your work. What you need to do is confirm that in writing, even via email. That's fine. Do something to get a contemporaneous, timely reminder of what you're agreeing to. People's memories are fallible. We don't remember, for a lot of people, what they had for lunch on the weekend. Of course you don't. It's not an important thing. Yes, contracts are important, but you don't necessarily remember exactly what was discussed or whether everything that's important to the agreement was discussed. That's why you document things. That's why it's important to get something in writing, and you need to do it at the time the agreement was made. And the best way to get it confirmed is to send an email. One of the ways, or one of the techniques that we use, is what's called a guillotine provision. So you send an email and you say, here's what we discussed, here's what we agreed, and unless I hear from you in 7 days to the contrary, I'll take that as your acceptance of what I've written here. That's one way of confirming and getting a really clear acceptance without relying on the other party to come back to you and actually confirm. Now, they can try and refute that in the future, but if they've been provided the opportunity to review what you've written and they normally respond in the time frame that you've given them, it's very hard for them to argue why that shouldn't be binding on them in the future. So there's a very, very quick overview. You can think about it as the who, what, why, where and how of contracts. Just keep those things in mind when you're looking at going into an agreement. and you're 3 steps ahead of over-enthusiastic people who just jump in and don't think about what they're doing before they sign or enter agreements with people. All the best.